Hello, I'm Casiana from R&R Partners Bucharest, and today we'll discuss about legal working hours in Romania. It's important to know from the beginning the daily schedule that you are going to agree with the employer, and from the perspective of the fact that sometimes it can be abusive and outside the legal norms. In order to know better what your rights are as an employee, we'll discuss about the working time according to the labor code. What's working time? Intuitively, working time represents the period in which the activity is actually carried out, but it's also important to mention that the time to the workplace and back to home can represent also a part of this notion. When we analyze these aspects, by working time, we also mean the fact that we are at the disposal of the employer and perform the related tasks, regardless of whether we work physically in the office or in a work from time regime. What's the statutory working time? In the case of a full-time contract, the working time is represented by 8 hours per day and cumulatively 40 hours per week, but there is the possibility that the schedule will be uneven, so that after 5 days there will be 2 days rest. In principle, the employer must comply with the norm of 40 hours per week, but it's also possible to negotiate in certain sectors of activity that the working time per day be shorter or longer than 8 hours. Given that an employment contract can be concluded with a person who is at least 50 years old, it's useful to know that for those under 18 years old, the working time is reduced 6 hours per day and 30 hours per week. It's a fixed limit of 40 hours per week? No, 48 hours per week can be considered as maximum duration, including possible overtime. There is an exception for extending this duration only if the average working hours are calculated over a period of 4 calendar months, and the result is a time that doesn't exceed 48 hours per week. What's the regime of overtime work? In principle, additional work is carried out with the consent of the employee, but exceptionally for situations of force majeure, urgent work to prevent accidents or remove the consequences of an accident, the principle will not be applied. Of course, it will be compensated by granting a sum of money, the equivalent of the working hours, but also some free hours in the next 90 calendar days, or salary increase will be granted. Those under the age of 18 cannot perform additional work. Is night work different? First of all, we will consider night work only the activities which take place between 10 p.m. and 6 a.m. and will be considered a night employee who performs at least 3 hours of his activity time or 30% of his monthly working time, but he will not exceed an average of 8 hours per day, calculated over a maximum reference period of 3 calendar months. Benefits, such as a reduced work schedule of 1 hour from the normal working day, will be granted for days when they work at least 3 hours per night, without affecting the basic salary. In a similar way to overtime work, young people under the age of 18 cannot perform night work, and the same situation applies to pregnant women and those who are breastfeeding. If you want some legal advice, please don't hesitate to contact us at this email or this phone.